things over to we are going to get started and turn things over to our guest speaker today, Robyn Powell. We are very excited to have her with us talking about protecting the rights of disabled parents involved with the child welfare system. So I'm going to let her take it away and tell her a little more about herself and get started with our topic.
Thank you, and thank you so much for inviting me here to speak today. My name is Robyn Powell. I am a professor at the University of Oklahoma College of Law. I'm also a senior research associate at the National Research Center for Parents with Disabilities. And so I'm here representing both. And I have spent over the last 10 plus years working on issues surrounding the rights of parents with disabilities. It is something I feel very passionately about, which will probably come through hopefully today. But really, I want to just give a really broad understanding of what the experiences are of disabled parents who find themselves involved with the child welfare system. So just to give you a little information on who the National Research Center for Parents with Disabilities is, we are a cross-disability initiative. We are guided by the disability community's ethos, nothing about us without us. We have a strong advisory board, which consists of all parents with disabilities, and the center conducts services, research, and advocacy. We provide instruction as well as information about health and parenting services for parents with disabilities and their families. And we are also funded by the National Institute for Disability, Independent Living, and Rehabilitation Research, as well as the Lurie Institute for Disability Policy at Brandeis University. So now I'm going to go to slide 13. So here is an overview of my presentation today. I'm going to begin by providing a description of the ADA and how the ADA defines disability and how one can identify whether a parent has a disability. I'm then going to talk about the intersection of disability law and the child welfare system. Then I'm going to talk about the systemic barriers that parents with disabilities face when involved with the child welfare system. I want to then discuss some recent enforcement efforts by the Department of Justice and the Department of Health and Human Services Office for Civil Rights, as well as some recent decisions that have come out of courts across the country that really show what courts are thinking about when we think about these issues. I want to conclude by discussing strategies and solutions for advocacy. So what to do when working with a parent with a disability involved in the system. And finally, I will end by opening up for questions and answers. So please do add questions as we go. And at the end, I will answer questions. I'm going to save them for the end, though. Okay, so the first question we always have to think about is sort of who is a person with a disability under the ADA as well as Section 504 of the Rehabilitation Act. And there are three ways that one can meet the definition of a person with a disability under both laws. The first is if one has a physical or mental impairment that substantially limits one or more major life activities. So again, it is very broad, a physical or mental impairment, and it just needs to substantially limit one or more major life activities. Major life activities is a very broad term. It includes things like walking, hearing, seeing, really thinking, remembering, reading. It can be very open. So you should remember that. The second way that you can meet the definition of having a disability is if you have a record of such an impairment. So this would be, for example, someone who maybe previously had cancer, they no longer have it, but they are being discriminated against based on that history or that record. So while they no longer have a disability under the law, they are being discriminated as if they still had that disability, that record. And then the third way you can meet the definition is by being regarded as having such an impairment. This might be someone who has maybe some mild depression. It doesn't reach the level where it's substantially limiting someone in any sort of major way, but they do have it. And because of that, they are being regarded as having an impairment that is actually substantially eliminating one or more major life activities. So I always, I'm a law professor first, and I always tell my students, the first is really the actual disability, whereas the second two are really how society treats someone based on some presumption of disability. So who then is protected by the ADA? Again, broad definition. It includes, of course, physical disabilities, includes sensory disabilities, whether that is sight, hearing, speech disabilities. It also includes intellectual and developmental disabilities. Intellectual and developmental disabilities are generally categorized by having some type of significant limitation in both intellectual functioning as well as adaptive behavior. Generally, an intellectual developmental disability originates before the age of 21. IQ tests continue to be sort of the major tool for identifying whether one has an intellectual disability. And I want to note that parents who have intellectual disabilities generally are seen as sort of the mild to borderline cognitive impairments. Generally, advocacy and research considers anyone who has an IQ below 80 or below to have an intellectual disability in this category. So it is fairly broad, recognizing that it is generally people who have sort of that mild to borderline impairment. Psychiatric or mental health disabilities are also covered by the ADA. This can include things such as depression, anxiety, post-traumatic stress disorder, bipolar disorder, schizophrenia, or psychotic disorder. It's really any impairment that's substantially limiting a major life activity such as parenting, social functioning, or really some major bodily functions such as regulating mood or decision making. And then finally, it's really important to understand how substance use comes into this, because so many folks involved with the child welfare system do in fact have substance use disorder. So drug or alcohol addiction is a disability under the ADA with several caveats. The first is that current and illegal use of drugs limits that protection. And so if you are currently using an illegal drug, then you are not protected by the ADA. But otherwise, Title II does prohibit discrimination against people with substance use disorders based on the fact that they have previously used. There are arguments to be made around sort of relapse as part of recovery, and so that should still be considered a disability. And I will note that the DOJ has been very involved in looking at how the ADA covers people with substance use disorders, including taking action within the realm of child welfare system, which we will talk about later in this presentation. So moving on to slide 16, then, just an understanding of sort of who are parents with disabilities and their children. There are a number of statistics on this slide, which I'll go through, but it's just important to understand that the research still is limited. And so these are all estimates. Estimates typically range from about 4.1 million parents, which is about 6.2% of all parents in the US having some type of disability, to other estimates that about 10% of children in the US have a parent with a disability, about 6.1 million. Other estimates have found that about 2.9 million parents in the US have a disability, and then other estimates have found that 10.3% of parents in the US have some type of disability. If you look more just at mental impairments, you can see that 2.7 million parents have a serious mental illness, and 12.8 have some type of mental illness. So what you should get from this slide is really, it is a substantial and growing number. It is anywhere from about 5% to 10% of US parents in the United States have some form of a disability. And that also means that 1 in 10 children in the US have a parent who has a disability. So this is a very large and growing population. Moving on to slide 17, understanding sort of what the experiences of parenting with a disability is today. Parents with disabilities experience considerable discrimination. They experience particularly high removal rates, that is the child welfare system removing the child from the home, particularly for parents who have intellectual or psychiatric disabilities. And research has found as high as 70 to 80%. There's also extremely high removal rates and loss of parental rights for parents who have sensory or physical disabilities. A recent study found that about 19% of children in the foster care system have a parent with a disability. That same study also found that parents with disabilities have 22% higher odds of having their parental rights terminated than parents without disabilities. And disability is always considered when determining the best interest of a child for purposes of a custody determination, whether it is in family or dependency court. So you can see that there is really pretty significant discrimination, particularly involvement with the system, removal of children, and ultimately termination of parental rights. And that is particularly high for parents who have intellectual or psychiatric disabilities, although all parents with disabilities are at risk. So moving on to slide 18, then, it's important to understand sort of what the child welfare system looks like for parents with disabilities. And so there are a number of recurring barriers that parents with disabilities encounter. The first is that 42 state laws, as well as the District of Columbia, currently include disability as grounds for termination of parental rights. So the vast majority, 42 and DC. Parents with disabilities also experience a disparate impact of certain provisions of the Adoption and Safe Families Act. For those not familiar, the Adoption and Safe Families Act, or ASFA, as the slide says, is the federal child welfare system law. Every state has their own law, but it is all based on the Adoption and Safe Families Act. And ASFA includes several provisions that, while do not include parents with disabilities explicitly, do have a detrimental effect on them. For example, there are very strict time limits. The state can move forward with terminating one's parental rights if the child has been removed for over 15 months, which can be really difficult for parents who have disabilities because it often takes longer to find the appropriate supports. Also, the Adoption and Safe Families Act requires parents to receive what they call reasonable efforts to be reunified with their children, but reasonable efforts does not often equate to actual accessible efforts. And so often what the state is providing may fit kind of under their definition of reasonable efforts, but it is not actually accessible. And then there are this issue around perceived limits on the application of the ADA. So many courts have found that the ADA does not apply to the child welfare system, might I say incorrectly have found, I believe. Particularly, courts have said it does not apply at the termination of parental rights phase. The courts have said essentially the ADA cannot be a defense to termination of parental rights. And because of these decisions, the child welfare system as a whole has interpreted this to mean that they don't have legal obligations under the ADA. As we'll talk about in a few minutes, there is movement on this issue, both by the DOJ and HHS, as well as some state courts sort of moving towards recognizing the importance of the ADA and the application of the ADA in these cases. There's just also a number of systemic barriers that parents, particularly parents who have psychiatric or intellectual disabilities, encounter. There are things like barriers to legal representation. Parents involved with the child welfare system in general do have the right to legal representation in almost every state in the United States. Not all, but almost every state. But because you are appointed an attorney doesn't mean that attorney is familiar with disability rights, how to work with a parent with a disability. And so often parents with disabilities are court appointed to attorneys that know child welfare law very well, but they don't know disability law very well. On the flip side, disability rights attorneys often know disability law, of course, very well, but they don't know child welfare law. And what all of this means is that parents with disabilities are lacking meaningful representation in these cases. So they are really at a disadvantage. There's also just access barriers. Just accessing the courts, for example, can be really challenging for certain people with disabilities. Parents with disabilities encounter vast attitudinal barriers, bias, and speculation. Everyone from child welfare workers to experts testifying in courtroom to even judges. So there is significant bias and speculation about parents with disabilities. Again, something I will get into later in this presentation. There's also just a lack of disability awareness and skill within the courts. Courts are not aware of parents with disabilities and how parents with disabilities can actually safely raise their children. And then there's just a lack of training and skills for clinicians, particularly those who are responsible for assessing a parent and then testifying at the hearing about that parent. If they go in not knowing about parenting with a disability, they are not going to be able to provide objective information for the courts to consider. So now moving on to slide 19. So the ADA and Section 504 of the Rehabilitation Act both apply to the child welfare system, undeniably. The Rehab Act is relevant because it applies to any agency that receives federal funding, and all state child welfare agencies do receive, so through the Social Security Act, they do receive federal funding. So when we're talking about these laws, I'm going to focus mainly on the ADA or Title II, but understand that Section 504 has mostly the same exact requirements. So as I said, Title II of the ADA applies to public entities, which include state and local governments and their departments and agencies. So this would inherently include the child welfare system and anyone that contracts with the child welfare system. It also includes courts. So that is very clear that the system needs to comply, and also that includes courts. So just to understand sort of what the child welfare agency is required to do, there are a number of legal obligations that the system has when working with parents who have disabilities. The first is that they must provide parents with disabilities an equal opportunity to participate in programs, services, and activities, and that would include reasonable modifications, unless doing so would fundamentally alter the nature of the service, program, or activity. So again, ensuring that one can access whatever the benefits are that the system is providing, and that may need to include reasonable modifications. The agency has to do so unless they can prove that doing so would fundamentally alter what they are doing. The second obligation is that they must administer their services, their programs, and their activities in the most integrated setting appropriate to the needs of the individual. This is the integration mandate that we often talk about when we think of the ADA. They cannot impose or apply eligibility criteria that would screen out or tend to screen out any parents with disabilities from being able to fully and equally enjoy any service, program, or activity. They must also provide auxiliary aids and services to parents with disabilities to ensure effective communication. That would include things like sign language interpreters, captioning, digital formats for materials, large print, anything that is really facilitating accessible communication. They need to provide, as necessary, benefits, services, or advantages beyond those required by the regulations in order to ensure access. So that means that the child welfare system might need to do more than they would generally do with a non-disabled parent in order to ensure that parents with disabilities are in fact accessing their services and that they are in fact not being discriminated against. They also cannot impose surcharges on parents with disabilities, so they can't charge a parent with a disability for any accommodations that they do provide. They cannot charge anyone. They cannot deny a program, service, or activity to a parent simply because it's inaccessible. They cannot say, for example, while we would love to provide this parent a parent training class, unfortunately, it is in an inaccessible location, therefore we're not going to provide that. They cannot do that. They will need to move it. And finally, They must provide services, programs, and activities that, when looked at in their totality, are readily accessible to and usable by people with disabilities. So again, they need to be broadly accessible to parents with disabilities. That is any service that is provided by the child welfare system. So what's really critical to understand when we're talking about child welfare system cases, and as is shown on slide 22, there are two fundamental principles of the ADA that I think are most important to understand when we're talking about these cases. The first is that parents deserve and have the legal right to individualized treatment. They must be assessed and provided services based on their individual circumstances. They cannot be discriminated based on biases against all parents with certain disabilities. Everything needs to be individualized to that person. And the second is they must have that full and equal opportunity in everything that is provided by the service in the system. So really, those are the two most important fundamental aspects of Title II of the ADA when we are thinking about these cases. Moving on to slide 23, this really goes over sort of first what that individualized treatment looks like. So it means that disabled parents must be treated on a case-by-case basis, consistent with facts and objective evidence. Disabled parents may not be treated based on generalizations or stereotypes. So that is really, really important. And to give you some examples of what would not be allowed, removing a child from a parent with a disability based on sort of that stereotypical belief that would be unsupported by an individual assessment that parents with disabilities aren't able to safely care for their children. So they cannot say, for example, we know all parents with X disability cannot care for their child, so therefore we are going to take this child away. That would be completely in violation of this individualized treatment mandate. Another example of something that would be denied, or rather would be going against the ADA, is if the agency denied a person with a disability the opportunity to become a foster or adoptive parent based on stereotypes about how that person's disability could affect their ability to care for a child. So again, this individualized treatment is so crucial to parents with disabilities, and it must be afforded to them. So now looking at the second principle on slide 24, the second one is, of course, full and equal opportunity. Disabled parents must be provided opportunities to benefit from or participate in all programs, services, and activities that are equal to those extended to non-disabled parents. They must have access to everything that a non-disabled parent would have. And this can require, as we've talked about, sort of the provision of aids, benefits, and services that might be different from those that are provided to other parents where necessary in order to ensure an equal opportunity to obtain the same result or to gain the same benefit, including family reunification. So this really means that in order to provide a full and equal opportunity, the agency might need to go beyond what they would generally do for a non-disabled parent in order to really level the playing field, in order to achieve an equitable outcome. So really important to understand when we're looking at these two principles, and this comes on slide 25, and it comes directly from the DOJ HHS technical assistance that was published several years ago now. This individualized treatment and full equal opportunity does not mean that we have to lower the standards for disabled parents. We're not saying you have to lower the standards. Rather, we're saying that the law requires that services need to be adapted and tailored to meet the parent's needs in order to provide meaningful assistance and make sure that that parent can benefit. This might mean ensuring physical or programmatic accessibility, or providing auxiliary aids and services to ensure adequate communication. For example, the Child Welfare Agency must provide an interpreter for a father who is deaf when needed to ensure that he can participate in all aspects of an interaction. It may also mean making reasonable modifications to policies, procedures, or practices. And for example, if a child welfare agency provides classes on feeding and bathing children, and a mother with an intellectual disability needs a different method of instruction to learn the techniques, the agency will need to provide the mother with that method of teaching that she needs so that she can benefit. So really, again, I can't emphasize this enough. Individualized treatment and full and equal opportunity are critical to ensuring that parents with disabilities rights are met by the child welfare system. So moving on to slide 26, There are, of course, a number of exceptions or defenses that are available to the agency. The first is fundamental alteration. Essentially, that means that if the agency can say, you know, we would love to provide this accessible method of training or skills, but it would completely fundamentally alter the program that we currently offer. They could argue that. The second is they could argue undue financial and administrative burdens. Generally, that means it costs too much. That is a high burden. These are all high burdens. They would essentially need to show that there was no money in an entire state's budget in order to provide a service. That is a pretty high burden to meet. And the third defense is that providing a service or accommodating a parent would result in a direct threat to someone else. You know, and this would be in the case of the agency saying, listen, it's just not safe for a parent to care for this child. I want to emphasize that all three of these exceptions or defenses are pretty high bars to meet. It will be on the state, the agency, to prove this. And so one should not worry too much about this. It's a pretty high burden to meet. Of course, possible, but hard. So as I've alluded to throughout, the Department of Justice and the Department of Health and Human Services have been actively enforcing the ADA in these cases. And on slide 27, I have a timeline of what that has looked like. So on the slide and on the timeline, you can see that the DOJ and HHS first really got involved in these cases in January of 2015. This was with what we call the Sarah Gordon letter of findings. I'm going to talk about that later, the Sarah Gordon case, in about 2 minutes. So I'm going to just leave that there for now, but we'll return to it. About 8 months later, in August of 2015, the Department of Justice and the Department of Health and Human Services issued technical assistance. It is a really important document that really details exactly how the ADA applies to the child welfare system and what the child welfare system must do in order to comply. I highly recommend, if you have not seen it, to look at it. It is really, really crucial. We'll talk about that more in a minute. So then you can see after 2015, we didn't see a lot of enforcement for about 4 years. And then in December of 2019, the Health and Human Services Office for Civil Rights entered a voluntary resolution agreement with the state of Oregon's child welfare system. This was in response to, amongst other things, two parents who had intellectual disabilities who had both of their sons removed. And the HHS's Office for Civil Rights found that Oregon did, in fact, violate the ADA by removing the children, by not providing accessible services. The family was ultimately reunified. And then about a year later, in November 2020, this Department of Justice and HHS actually entered a settlement agreement with the state of Massachusetts. That is important to note because the Sarah Gordon letter of findings, which we'll talk about in a minute, was actually in the state of Massachusetts. So back in January 2015, the agencies said, listen, the Massachusetts Department of Children and Families violated the ADA by discriminating against a disabled parent. And now fast forward 5 years, and DOJ and HHS went back to the state because they had received more complaints and said, essentially, we meant what we said. You do actually need to comply with the ADA. And so this was a settlement agreement that was reached. Move along about 5 months and we get to April 2021, and there was a settlement with the Department of Justice with the state of Washington's Child Welfare Agency. This was in response to not providing accessible communication to deaf parents. They were not providing sign language interpreters. And so DOJ came in and essentially said, you know, you violated the ADA. There was a settlement agreement that was reached. About a year later, in March 2022, the Department of Justice and HHS entered into a settlement agreement with the state of Rhode Island. Again, talking about sort of the obligations of the Child Welfare Agency, also extending to foster care parents with disabilities, and really saying you do need to comply. And then most recently this month, earlier this month, the HHS's Office for Civil Rights entered into a voluntary resolution agreement with the state of Pennsylvania. This was in regards to parents who wanted to be foster parents or adoptive parents who had substance use disorder histories. They were using medicated assisted treatment, such as Suboxone, And the agency really emphasized that that is covered under the ADA and that the person is not actively using if they are receiving medicated assisted treatment, and that you cannot discriminate against a prospective foster parent based on that history or that substance use disorder. And so, to my knowledge, this is all the enforcement activities. Of course, I could be missing something, but these are the big ones. And you can see that I would say there's been an uptick over the last couple of years. And I will also note that's not on this because nothing has fully come out yet, but the Department of Justice, we saw in the news several months ago, is now looking at how algorithms are being used against parents with disabilities by the child welfare system. And according to the news, they are currently investigating in Allegheny County in Pennsylvania, looking at sort of algorithmic bias against parents with disabilities. So one can assume that more will come out in the future on this issue. So moving on to slide 28, I alluded to this a few minutes ago, this Sarah Gordon letter of findings. I think it's important to understand it because it was the first. And the first is always important to note. So this was a letter of findings that came out from the Department of Justice and HHS together. It was a joint letter of findings. They had investigated a case involving a young mother with an intellectual or developmental disability. She had had her child removed shortly after giving birth. She hadn't even left the hospital yet. And her child was removed after the hospital observed that she was having some challenges around feeding, diapering, some really pretty typical things, particularly for a young new mom. She was only 19 at the time. She, I will note, had a really strong support system. She had a family that was very willing and ready to help her. And the state really didn't care, and they took the child away. The child was in foster care for several years, and Sarah, the mother, had very limited access to her daughter during that time. She was able to get the Department of Justice and the Department of Health and Human Services involved in her case. They investigated her situation. They found in this letter of findings that the state violated both the ADA and Section 504 of the Rehabilitation Act. And in doing so, they said in their letter of findings that the state must provide the mother appropriate supports and opportunity to demonstrate her fitness. Really, that just means that you have to allow the parent to even show it. You are now acting based on just bias, not individualized treatment. Ultimately, after a really awful experience, the family was reunited 2 years, 3 months, and 12 days later. But remember that this family lost the first 2 years of this child's life. They will never be able to get that back. So again, I think this is an important case, and it is available online, this letter of findings. I mentioned a little while ago also, shortly after the Sarah Gordon letter of findings, in August of that same year, DOJ and HHS issued joint technical assistance. This was a document issued in August 10th, and it really is great. It provides an overview of all of the issues and understanding of the application of the ADA in Section 504 to the child welfare system. It answers really, provides answers to really specific questions and implementation examples for child welfare agencies and courts. It really just provides really important information. I think it provides also resources to consult for additional information. It's also available online. I highly recommend that anyone that's interested in this topic or who's working with families look at this technical assistance. I've seen courts cite it. It's just really strong, and I frequently look at it. So it just provides a really deep understanding. So now I want to move to a few different cases that have come up. So we've seen really strong enforcement efforts by the Department of Justice and the Department of Health and Human Services Office for Civil Rights. Concurrently, we have seen courts start to recognize how the ADA applies in these cases, and I'm going to highlight a few that I think are relatively good changes. And while they are specific to specific states, I have seen other state courts look to these decisions and moving forward and evolving in this area. So I think they still are helpful, even if you're not in, for example, Michigan. So this is a case out of Michigan. It went all the way to the Michigan Supreme Court. It involved a mother with an intellectual disability. The mother had gone to the child welfare system. She was unhoused at the time and she needed supports. They took her child away, and they were quite aware that the mom had an intellectual disability. Her lawyer had really asked several times for reasonable accommodations. and she was never provided reasonable accommodations by the agency. Ultimately, through the courts, they did reverse the termination of parental rights. So when it first went to the lowest courts, they terminated her parental rights. And on appeal, the appeals court and then the Supreme Court said, listen, the agency and the court have a responsibility to ensure that a parent's disabilities are reasonably accommodated if they know of or should have known of the disabilities. This was really strong language. It put a lot of onus on courts and the agency to really step up and say, look, if you know a parent has a disability or you have a reason to believe a parent has a disability, you need to do something. You need to accommodate this parent. And it really does place that responsibility on the courts. And before this decision, the parent had to raise the ADA, or it could not later on appeal waive it, raise it rather. So if you did not raise it at the beginning, it was over, it was done. You couldn't later say the ADA. This is a really strong case. And what the slide doesn't say that I think is equally important is it talks about how a state has to provide, as I mentioned, reasonable efforts to reunify a family. And what the case does here is it says reasonable efforts dovetail with reasonable accommodations. And what that means is efforts are not reasonable if they do not accommodate a person's disability. And while that might seem obvious, it was not something that was being recognized by courts or implemented. So I really like this decision. Again, this is In re Hicks Brown, came out of the Michigan Supreme Court about 6 years ago now, but it's a really strong case, and I've seen other states look to it. I want to also talk about a few Colorado cases that are relatively recent. So the first is People XREL CV, and it was a 2015 case. It involved a mother who had a psychiatric disability, and she was, according to the agency, unwilling to comply with the mental health plan that was being forced on the family. Also, the father had a psychiatric disability, so the agency was essentially saying, mom is not complying with the mental health treatment. The parents also had their older children, they had their parental rights terminated for their older children, so they had a history with the system. The trial court, so the original decision, found that there were no appropriate treatment plan that could be devised to address the parents' quote unquote unfitness due to their disabilities. So essentially the trial court said, the agency, there was nothing they could do. There was nothing that would be able to address this. It's just impossible. The parents appealed this, and I will say, in case folks know, this was litigated by Carrie Ann Lucas, who is a very well-known disability rights lawyer out of Colorado. And although this case ultimately was not successful for the parents, she really thought that this really was important for parents with disabilities, and I would agree. So it wasn't successful. Ultimately, the appeals court found that although the ADA does not limit the court's authority to terminate a disabled parent's rights, when the ADA can't, when the parent can't meet the child's needs, the ADA still does apply. So the ADA applies to providing assessments, to providing treatment, and to providing other services that a department would provide to parents through a dependency and neglect proceeding before a TPR, termination of parental rights hearing. Again, not a great outcome for these parents, but this was the first time the Colorado court actually recognized that the state, and specifically the Child Welfare Agency, did in fact have obligations under the ADA. So not an ideal outcome for this family, unfortunately, but it was the first real recognition that the state of Colorado's Department of Children and Families would in fact need to comply with the ADA. So we have this case, and then a couple of years later, we had the SK case out of 2019, both again from Colorado. And this case involved a mother who had intellectual and psychiatric disability, and she had a child. And at the initial hearing, the juvenile court had said that the parents' disabilities severely limited that their ability to care for the child. And the parents, of course, appealed based in part on that earlier decision I just talked about. And they said that the department did not make reasonable efforts to reunify with the child or to rehabilitate them in light of the ADA and Section 504. Again, this is one of those instances in which, unfortunately, the appeal was unsuccessful. But again, the courts finally are recognizing that they do need to think about these things. The court said that it needed to consider if reasonable efforts were made to rehabilitate the parents, and that standard is met when the services are provided. They also went on to say that the department and juvenile court must account for and make reasonable accommodations for a parent's disability when making a treatment plan. So again, it further extended sort of understanding of the role of the ADA. I'll also note that Colorado also passed, with really the work of Carrie Ann Lucas, some really strong legislation on parents with disabilities, which has really codified all of this into their laws. So I would look to these decisions for some really good language on sort of what courts and states must do. So I want to now move on to sort of this question I get all the time, which is sort of what I represent a parent with a disability, or maybe I represent a parent with a disability. I don't even know. What do I do about that? What am I supposed to do with this? And I want to really now focus for the next several slides, starting on slide 34, on sort of what do you do? What do you do if you have a parent with a disability that you're working with, or that you think that parent might have a disability? So the first thing is, I believe that when representing parents, you need to screen every individual to see if they have a disability. Often, and very understandably, parents with disabilities are reluctant to identify as having a disability because they are aware of the stigma that is attached, particularly to invisible disabilities, things like intellectual disabilities or mental health or psychiatric disabilities. So they might not just stroll into your office and say, hey, I have a disability. So it's really important, because we know that A, a lot of parents with disabilities are involved with the system, and B, we know that there are protections available to parents with disabilities. It's important you screen every single client to determine if they have a disability. And these are a number of questions that you can ask that don't explicitly say, do you have a disability? It really starts to warm up the conversation and get to that point. So you might want to ask the individual, did you have an IEP in school? Of course, if they did, that would mean that they had a disability. Do you receive SSI or SSDI? Again, of course, that means that the parent probably has a disability. Things like, do you have trouble learning new things? Do you use pain medication on a regular basis? Can you work? If not, why? Are you able to walk upstairs? Really ask also specifically about the allegations against them, even if they aren't true. So say, can you tell me why the child welfare system is involved? What are they saying you did? Even if it's not true, just explain to me what they're saying. And asking these types of questions can start to get that conversation going about whether the parent has a disability. And if they do, then you have to decide whether the ADA will be useful. So these are really important and helpful questions to sort of bridge that gap and really start that understanding. So moving on to slide 35, one of the big things I think is important for people working with parents with disabilities is to connect the parent with appropriate disability services and supports that can provide that parent with assistance with housing and employment, transportation, personal assistance services, financial or health benefits, really anything that they might need. I often will say, the extent that we can get parents supported outside of the child welfare system, I think is best, because the child welfare system is not equipped to support parents with disabilities. We see that. So referring parents to Centers for Independent Living, the ARC, many local ARC chapters have programs for parents who have intellectual disabilities, peer supports, particularly if a parent has a mental health or psychiatric disability. Again, try to make sure that they are well connected to available supports and services. You're really trying to bring the best version of this parent to the court ultimately. So you want to make sure that they are well supported, because that will show that they are well supported to care for their child or children. You want to also make sure that parent receives adaptive parenting assessment that is conducted by someone who has experience evaluating parents with disabilities. Almost every person involved with the child welfare system will undergo a parenting assessment, and unfortunately, many of these assessments are not conducted by people who know anything about parents with disabilities. So this is really important that you get an evaluation done by someone who knows what they're doing. For example, evaluations that are specialized for people with intellectual disabilities. Make sure the person is knowledgeable about support services, adaptive parenting equipment. Make sure that they're using an appropriate measure to assess parenting. I've read evaluations where they've sort of just looked over one's medical records and made determinations without even meeting with the parents, or by meeting with the parents for a half hour in an office. None of these mechanisms are good for actually assessing one's parenting capabilities. Really, observation in the home setting is crucial during an evaluation. It is best to be able to understand the functioning of the parent and the parent-child dyad when they are in their natural environment. You know, if you ask someone to show how they can care for their child in an unfamiliar environment, it might not be accessible to them. It might not be it won't have their typical adaptations. People with disabilities, we set up our homes in certain ways that really work for us. And if you ask us to do something elsewhere, it might be more hard. We might not be able to show sort of our best abilities. Remember that the ADA and Rehab Act require parenting evaluations to be accessible, and that includes evaluators providing modifications as needed. For example, I knew of a parent who was required to do a reading assessment, which is all kinds of problems, but one of the problems was that she had low vision, and they were asking her to do this assessment with very small font, and they did not provide large font at all to her. And of course, it came back as her having pretty significant reading disabilities, which would not have shown up if they had accommodated her. It's also important to understand that IQ score does not correlate with parenting ability. There is tons of evidence on this, tons of research back, and yet if you look at parenting evaluations done by people not qualified, they often just use a IQ score to conclude that a parent can't care for their child. Moving on to slide 37, you want to ensure that the EA is followed at every junction, and that courts are making required rulings throughout a case. Bring up the ADA early and often. You want to develop that record and say, listen, we've been asking for patients. We've been saying the parent has a disability. We have been doing everything we are supposed to. You want to make that record. Also, consider filing complaints with the Department of Justice or the Department of Health and Human Services Office for Civil Rights. As we talked about earlier, they are engaged in enforcement, so this is an opportunity, I think. It's really important to really know the parent's disability, understand how their disability affects them, any sort of symptoms they have, medications they take, know their mental health history, understand sort of their recovery process, how they function. You really need to know everything about the parent's disability and how it affects them. If you are working with a parent with a disability, you should really work on communicating with their providers, their support systems, as we talked about, sort of obtain referrals, skill building services, classes, groups, education, etc. You want to obtain a clinical perspective on the individual symptoms and functioning. This will also be helpful for attorneys who are navigating the attorney-client relationship. If you can have that good understanding of how that individual's disability affects them, you'll be able to really work with them in a supportive way. You want to encourage providers to be appropriate advocates for parents. So providers know a lot about the individuals, and you want to make sure that they can be supportive of the parents and understand that providers can help to reinforce or explain or translate legal advice. So if you're an attorney, for example, you can work with providers to support your client. Also, I think it's important to know your client's strengths and abilities and be able to advocate for specific services and accommodations. Throughout these processes, parents with disabilities will continuously hear all the things they cannot do, all the things they are allegedly doing bad, and you need to know the flip side. You need to be able to identify, look at all the things this individual can do. Look at how they can do these things with the right services, with the right accommodations. Focus on the recovery process and the supports that your client is utilizing. Look at my clients. They go to peer support groups 3 days a week. They go to a clubhouse. Whatever it is, you want to really focus on that and bring that out, because no one else in the case is going to be doing that. No one else is going to be talking about the parent in a positive light. That is just the function of these cases. You want to ensure that the analysis of the individual parenting abilities, both the strengths or the gaps, in relationship to the individual child in the case, and the functioning and capacity, not disability alone, really look at the whole situation. Does the child also have a disability? Is the child older? All of these factors will go into sort of how this family unit functions. Then you want to educate the court about the process. Look at sort of alternatives to medical models. Acknowledge both setbacks and offer, credit where they've done good. Really come up with creative and practical accommodations and solutions. When they come in saying, look at your client can't do this, this, and this, and say, listen, my client can, and this is how they have shown that. And know things around evidentiary and legal standards around mental health records, and things like that, because courts will look at mental health records. And if you're a lawyer, sometimes you can argue that they should not be able to access certain records. A couple other things I wanted to highlight on slide 39, I have a list of biases against parents with disabilities. These are very common biases. They do not include everything, of course, but these are some of the common ones that parents with disabilities do face. So there are significant presumptions that IQ correlates with parenting abilities. Not true at all. Relatedly, there are presumptions that parents who have intellectual disabilities cannot learn and maintain parenting skills. There is substantial research to show that is not true. There are presumptions that parents who have psychiatric or mental health disabilities are inherently dangerous. Again, we know that people with mental health disabilities are far more likely to be the victims of assault and crimes than to be the perpetrators. There are presumptions that language development for a child of a deaf parent will be delayed. So some have argued in these cases, listen, how is this hearing child going to develop their language if they are to continue in a home with deaf parents? Again, all of these biases have been hugely proven wrong. There are presumptions that blind parents can't safely supervise their children, and there are presumptions that parents with physical disabilities cannot care for their children. I want to emphasize again and again, none of these biases are true. But these are the biases that parents with disabilities regularly encounter, whether it's in the child welfare system or outside the child welfare system. These are the common biases that disabled parents routinely encounter. And so you need to be aware of those and be able to confront them. Really look at who the experts are in these cases. They often will rely on clinical assessments. They will often sort of use a medical model to treat parents, and they'll use inappropriate measurements such as IQ tests. Understand sort of what is the influence of attitudinal bias, even with these experts. Are these experts biased against parents with disabilities? And understand sort of that there's often this generic approach by the child welfare system, this cookie cutter approach. Listen, we look for this in all parents, or we provide this in all parents. Any deviation from that cookie cutter mold is seen as bad. And so you want to be aware of that. There, as I've said several times, I just want to reiterate it one more time. There is this IQ myth that says that, if a parent has a lower IQ, they can't care for their child. This is just some of the research that proves that's not true. That a parent's IQ level is not indicative of their abilities, and that it is, and generally any challenges that parents with intellectual disabilities face is socioeconomic, it is related to the support systems they have, where they're living. It's outside factors, all factors that can be addressed. And research has shown that parents with intellectual disabilities are capable of learning and maintaining their parenting skills. This is important because the child welfare system will often say, what's the point of sending this parent to a parenting class? They won't be able to learn. And that is just simply untrue. And people can learn, particularly if their needs are met and they are receiving a method of instruction that is accessible to them. When we're thinking about how parents are evaluated, there is some pretty good guidance out there. In particular, there is the guidelines from the American Psychological Association on assessment of and intervention with persons with disabilities. I often will encourage attorneys, for example, if they know that the system has evaluated a parent, when you are questioning that evaluator, ask if they're familiar with these APA guidelines. Do you know the APA guidelines? How did you implement the APA guidelines? What did you do to make your evaluation accessible? And you will find that you can discredit experts very easily with these. Moving on to slide 43. Slide 43 and then slide 44 next really just provides examples of reasonable modifications that are common in the system, providing in-home modeling, parent education that's tailored to the parent, providing information in an alternative format. All of these things that you can see on the slides, on slide 43 and 44, are really good examples of sort of what accommodations look like or modifications look like. What I also want to emphasize is that no modification will be the same. And so you can use these as sort of a stepping stone or a starting place, but you really need to work with parents, and really parents need to be able to identify what helps them. So these are great examples of sort of a place to begin, but you can use these as sort of a starting point, not an ending point. Here's some additional resources that I would recommend. As I mentioned, I work for the National Research Center for Parents with Disabilities. We have a ton of resources on our website. We have webinars, we have fact sheets, we have information for parents, we have information for professionals that work with parents, we have information for lawyers, health providers, the child welfare system, again, parents and prospective parents. So we have a ton of resources available on our website. There's also the National Disability Rights Network. They are a membership organization. Every state has a protection and advocacy agency, which provides legal services to people with disabilities. There's also the Association for Successful Parenting. They are an organization focused on supporting parents who have intellectual or learning disabilities. They are great. They are great experts, particularly if you're thinking about evaluations for parents with intellectual disabilities. And then there's the Bazelon Center for Mental Health Law. They've done some really good work, particularly looking at the rights of parents with psychiatric or mental health disabilities. So on slide 45, here are sort of what I would recommend as additional resources to consider. And then slide 46, of course, mentions the National Council on Disabilities Rocking the Cradle report. This report came out almost 11 years ago now, September of 2012. And I was fortunate enough to be able to work on this report. Unfortunately, much of this report on parents with disabilities, little has changed. So it is still very accurate, unfortunately. And it is a really good resource for trying to understand these issues and these needs more and the rights more. So I think it is still a good resource, even though it is almost 11 years old now. And with this, I'm going to conclude and open this up for questions, but I will say again, feel free to reach out to me. My email is on slide 47, along with a link to the Center for Parents with Disabilities, which again, the National Research Center has tons of available resources for parents, prospective parents, and also professionals. And I will open this up. I'm not sure, I can start looking. Or do you want to help with that, Nancy?
Yes. Thank you, Robyn, so much for all of that really fantastic information and lots of great tips and resources. We do have some questions. And again, just by way of reminder for folks, if you have questions, type them into the Q&A box, and we will try to get to as many of those as we can. And I think actually one or two of them you've sort of already addressed, since they were put in there earlier. But there's one, I'll just start off with one that is seeking some clarification on something that you mentioned earlier about state laws. Are you saying that there are 42 states that use disability as a sole justification for removing children, or is it 42 states that have laws that just have some language around disability as a criterion for removing children?
Excellent question. So it is 42 states and the District of Columbia that includes some language related to some disability. I'm using this vaguely because it varies state to state. Many of the states include mental health disabilities or intellectual disabilities or substance use disorders, but even states include physical or sensory disabilities, including the state of Oklahoma where I live. And these state laws generally use disability as sort of, they require this agency to sort of show a nexus between the disability and the alleged harm. But we know from case law, from research, that often that nexus isn't really required by courts when this law allows for the consideration. So while in theory, the text may indicate that there is some onus on the state or the agency to at least move beyond just the label we see that often that label is used against the parent, and it is often used as sort of this checkbox to enable the termination. So again, the states vary state to state. The National Research Center for Parents with Disabilities has a map with all of these states, and if you go to the map on the website, you can click on whatever state you're interested in, and it will provide a summary of the law in that state as well as links to the actual text.
Oh, that sounds like a terrific resource for folks to drill down to their state level information a little bit. Now here's a question kind of about your experience. This is from somebody who works with a brain injury alliance, and finding a real lack of data around parents who are involved in child welfare systems that have some experience with brain injury. Are you finding that the same? Do you find that there's something significant there? They're saying we're seeing a lot of studies that are pointing to a really high incidence of brain injury incidents among people who have mental health diagnoses, substance use disorders, homelessness, any kind of involvement in the criminal justice system. Are you kind of seeing that in your experience?
Yeah, I mean, I think in general, there's very limited research on parents with disabilities, particularly on sort of like the prevalence. We have done some work at the National Research Center, so we've identified some of this prevalence. But I will say that there is still so much work to be done around sort of understanding specific disabilities. So brain injury often will probably be encompassed into research on either mental health or even cognitive disabilities, depending on who the researcher is. But I think it would be great to have additional research. So I'd love to see more of it. And I think sort of looking at how you mentioned how there is this sort of co-occurring disabilities, whether it's mental health disabilities, for example, but also, rates on people being unhoused for having substance use disorders, involvement in the criminal legal system. And we know that all of those factors increase one's likelihood of being involved with the child welfare system. So I think this research is critically needed.
We have a question in here about, if you're familiar with this concept of life sharing, and this is related to experience with parents who are being told that in order to have a chance for reunification with their children, the parent is going to need to have something like 24-hour care or in-home, assistance or something. Are you aware of any programs that work around those issues or help support those kinds of needs?
So I have not heard of life sharing. I guess that must be specific to Pittsburgh, I'm assuming, based on sort of the question. But I have seen the child welfare system across the country sort of have that requirement or expectation that there will be a non-disabled person there 24 hours a day. More than a decade ago now, I suppose, there was a blind couple in Missouri who was told they couldn't bring their child home unless there was someone with them 24 hours a day. And they didn't need that. And luckily, they were able to reunify with their child after about 57 days, but that's still almost 2 months of being separated. And it was, again, right after giving birth. So there is this really concerning, I think, expectation and assumption that someone's going to need 24-hour care. And the fact is that many don't need it. And also there's no funding for such a thing. So I think it's a very unrealistic expectation and probably unnecessary in a lot of instances.
That's a good point. It's a lot to think about here. There's a related question about this funding issue, I think, that gives us a good opportunity for segue here. Do you believe that, currently we're hearing a lot about a lack of funding for social service programs in general, and do you think that that is really having sort of an outsized impact on families with disabilities, parents with disabilities?
Well, I think that we are perhaps, well, I'm not even going to say perhaps, I think we are going about this the wrong way. I think that if you look at how funding is spent, we dedicate millions, if not billions of dollars every year to the foster care system. when we know it is much more fiscally responsible, cheaper to support families in the home. So I strongly believe we need to shift those dollars. I think the dollars exist. I just don't think we're using them in the correct way. And so if there's only so much money to go forward with something, I would argue that we should be putting it towards keeping the families together because, again, we know it's more affordable. We also know it leads to better outcomes. So while I appreciate sort of the funding issues, I think that it's there if we want it to be there.
Maybe a matter of thinking about our priorities. Huh?
Right, absolutely.
Now, we have several questions around something that you talked about pretty extensively in terms of assessments and assessing parents' capabilities and so forth. And so we have a couple questions about, seeking some clarity. Are you kind of saying that states are really required to have really a specific kind of tool or something unique? Can they use the usual tools or assessments that they use? Who are the best people? What kind of qualifications should someone have to really adequately, effectively make assessments? Should it be a doctor, a social worker? Maybe you can speak a little bit more around those issues, assessment.
Yeah, absolutely. So almost every family that finds themselves involved with the child welfare system, whether they have a disability or not, the parent is going to be required to go through some psychological assessment. And it's sort of one of those cookie cutter things that seems to happen in the system where we expect every parent to do this. So the state often use the same psychologists or psychiatrists or the evaluators, whoever they might be, to evaluate all the parents. And unfortunately, what we have found is these people that are used routinely are not skilled in evaluating parents with disabilities. So they don't have that extra training. So I think there's two ways to approach this. The first is if you're working with a parent, ideally, you would try to get the state to not use their general usual person and instead to find someone who has that expertise and that skill set. To be honest, they might not be so open to that, which leads to my second point. You can ask as an accommodation that the person undergo a parenting evaluation by someone who's an expert in this issue. Or if you are representing a parent, sometimes court appointments will allow for funding to get an outside expert. So the parent attorney can hire a second evaluator that can be someone who is qualified. There are a number of individuals that are qualified, and too many probably to name, although not enough. But there are, Through the Looking Glass does some evaluations on parents with disabilities. There's also several people affiliated with the Association for Successful Parenting who are very skilled at evaluating parents who have intellectual disabilities. And in fact, one of them, Dr. Nicole Brisson, was highlighted in that Sarah Gordon letter of findings. And I know that Dr. Brisson and others have really worked hard to sort of increase the number of individuals who are sort of qualified to conduct accessible parenting assessments. So there are more and more. And they've also worked with agencies across the country to sort of educate them on what they need to be doing in order to evaluate. So it's not necessarily the type of professional. I wouldn't say there's a social worker or a psychologist, but really the person themselves. What are their skill sets? Have they evaluated parents with disabilities before? What are their approaches? These evaluations that are generally the best are based on this competency-based approach, where they're going in and instead of looking at like what the parent can't do, they're looking at how can we support this family so they can continue to be together. And that is really sort of the approach that I think is best, whereas so many of these evaluations are really awful. Generally, these experts, again, they will look at the person's medical records, maybe meet with them for a half hour, an hour, and then they make this entire evaluation based on very little, including not even observing the parent and child together. And so those are highly discriminatory. If you look at the language of them, they're very ableist, for example. They use really awful criteria. So again, when working with these families, you just want to make sure that they're getting evaluated by the best. And again, that doesn't mean that you're going to be able to stop the state from using their evaluators, but you can often get at least a second evaluation And then you go into court and you have the second evaluation, while also sort of trying to show or attack, but that's not the right word, sort of go at the credibility of the first person. So show that the first person wasn't a credible source because they weren't equipped. Whereas my evaluator, the second evaluator, is qualified. Look at, they've done hundreds of these evaluations. They are skilled. They have done all of this extra training. They have the qualifications to actually make an objective assessment.
I wonder if maybe that expertise even could vary depending on the nature of individuals' disabilities, because that obviously would be a factor. Communication issues for people who are deaf or hard of hearing, or knowledge of people with intellectual disabilities versus people who are blind, are going to have some different factors, I would imagine, in doing those assessments.
It really, that's absolutely true. And I point out sort of intellectual and mental health disabilities only because those are the parents that are the most involved in this system and that really encounter the most significant biases, discrimination, but this isn't relevant for all parents of disabilities. I will also say, since you brought up blind parents, the National Federation for the Blind has done a lot of work on parents with disabilities, and our parents who are blind rather, and really strong advocacy and support for parents who are blind. So they are also a really great resource.
Oh, that's fantastic. You're giving us so many great resources. I mean, we did have another question from somebody who wondered if you had any other sort of knowledge of national level advocacy efforts or organizations that are working around in this area.
Yeah, so as I mentioned, the National Research Center for Parents with Disabilities, we have NIDLR funding, so that's what we do. There's Through the Looking Glass, which again is an organization that's existed for several decades now, and they are focused on parents with disabilities. There's the Association for Successful Parenting. They are US based. They also have sort of an international membership. National Federation for the Blind has done some really good work. The National Council on Independent Living has done some really good work. We're seeing a lot of independent living centers really take up these issues. And we're seeing state level advocacy. So on our National Research Center for Parents with Disabilities website, there's a second map that shows the state advocacy that's occurred across the country, where many states have either introduced or passed legislation really aimed at protecting the rights of parents with disabilities. So about 30 states have either passed or introduced laws related to parents with disabilities, trying to increase the rights of parents with disabilities.
Interesting. That's great. And I'll just remind folks that and we put the link in the chat there where you can download the handouts of the slides, and all the links that Robyn's referred to here they're all live and active in that document, so that you can, if you download those, you can click on all the great resources that Robyn's included for us here today, and visit some of those resources. It's been a terrific information. Let me see. I don't know if we have any other questions at the moment. Again, if you have additional questions, please type them into the Q&A box. Now, here's a question. Do you find that ACE studies influenced the bias against parents with disabilities?
Yeah, so ACE's adverse childhood experiences. And so that's what ACE stands for, ACEs. And I think that we see that the early research on parents with disabilities and their children really was focused on finding problems. And I always say, if you're looking for a problem, you're going to find it. And so, it really has it tried to find and identify adverse childhood experiences, but it didn't look at the causes. So there was this assumption that, if a child of a parent with a disability is having a poor outcome, that must be because of their disability. Whereas newer research, including out of the center, but also international research and others in the US, are finding that it's not the disability. It's generally circumstantial. It is, they don't have enough money. They don't have enough support. They have inadequate housing. Again, all of these problems that can be solved, and not because of the disability. It could be racial discrimination. It can be class discrimination. So again, I think that the earlier research was really focused on finding problems and then blaming the disability and not recognizing how biased that is. And it was highly based on sort of assumptions that a bad outcome meant that children of disabled parents were going to fare poorly, when that is not the case. And newer research has really proven that.
Sort of an assumption about the inherent badness
Yeah,
of disability.
it's really great because new research has also kind of flipped the script, I would say, because it has also focused on sort of the strengths that come out of having a disabled parent. So we find that children of disabled parents are more resilient, more independent, more compassionate, better advocates, really committed to social justice, all of these other great things that earlier research was so focused on finding bad that they didn't even consider like the good that could come of it.
Interesting. Very, very interesting. We don't have another question right here at the moment, so we're going to give people another couple minutes, but in the meantime, maybe we'll move on to our final couple of slides, share our contact information. If you do have follow-up questions, and Robyn was kind enough to share her contact information, but you can always contact us here in the Mid-Atlantic ADA Center or your regional ADA Center if you have questions about any aspect of the ADA. Now, here we have another question here. Do you have any specific advice for ADA coordinators in the child welfare field, people who are assigned in any of these child welfare agencies to really handle ADA compliance issues?
I mean, I think there's a few things. So training, my really experience has been that child welfare workers lack training on how to work with parents with disabilities, also that they just don't have any knowledge about parents with disabilities, or that they have legal obligations. So making sure that they're aware of their legal obligations, how to work with parents with disabilities. Also look at your policies, because I have looked at some states' ADA policies, their child welfare ADA policies, and they're all related to employees with disabilities and really nothing to do with parents with disabilities. So really, I would say just, make sure that your agency is really prepared to support parents with disabilities. Check your policies, make sure they are really actually encompassing disabilities, parents with disabilities, all disabilities, and really make sure that every employee is aware of not only their legal obligations, but also how to support parents.
I think that is just an excellent, excellent piece of advice. We tend to find that that's a common thread that runs through not just child welfare related agencies, but any and all kinds of agencies under Title II and even under Title III, or just across the board, is that if you don't train your staff, then they don't know what to do. It's just a really, really important piece.
I've done trainings with child welfare workers, and I always sort of start by saying, can you tell me your legal obligations under the ADA? And it's sort of looking at me with deer in headlights. And then I say, like, do you even know you have obligations under the ADA? And the answer is generally no. And so how can we expect providers to comply or agencies to comply if they're not even telling their employees that they have these obligations?
Yeah, it's a big need, and we often we notice that when the federal agencies enter settlement agreements, consent decrees, and so forth, they typically include requirements for the agencies, to conduct staff training. So it sort of really indicates how critically important it is for really effective, meaningful implementation of the ADA, that it's just one of those routine items that we see over and over again. You've got to train your staff so that they will know what to do. So I think, let me just check here, because we do still have a few minutes to see if we have any additional questions. Someone here has just shared the website for Through the Looking Glass, which is lookingglass.org. and says there is currently a survey going on for parents with disabilities. So sounds like there's a little research opportunity there, a little opportunity for parents with disabilities to participate in building some of that data that we were talking about lacking. So maybe check that out, folks. Go to lookingglass.org, and there may be an opportunity to help inform future efforts around these needs by letting the researchers know what your thoughts are, what your experiences are. So thank you for sharing that. And we have lots of folks chiming in on the Q&A and in the chat and everything, saying that what a terrific session this was, and they really learned a lot. And it's a lot of great valuable information with multiple exclamation points. So I think that this has just been incredibly informative and very helpful. So again, Robyn, do you have any maybe final thoughts for us?
Well, I will just thank everyone. I'm excited when people are interested in this topic, and clearly there was great interest. So thanks for sticking with us for an hour and a half. And thank you to my dog for not barking. I was very deeply concerned. I have a brand new dog, so I did not know how that would go. But also really feel free to reach out to me anytime. I'm really open and happy to answer questions. This is clearly something I'm very interested in. So please, I mean that. It might take me a day or two to respond, but I will respond.
Well, thank you. Thank you again so much, Robyn. This has been terrific. And thank you, one and all. Thank you for joining us this afternoon. Again, go to our website to download the slides and get all this information, and enjoy the rest of your day.